Hour. This is how America learned. This is how we all learned who won the presidential election in the year 2000. Watch.
NBC's Dan Abrams and Pete Williams are just outside, and they are reading the ruling even as we go to them. Pete, what do we know? Is this a split decision?
Well, it would appear to be so, Tom. It's what's described as a per curiam opinion, which means it's not signed by any single justice. The senior justice dissenting here, Justice John Paul Stevens, I think, leaves little doubt that there's no room for a recount. So does Justice David Souter. Justice Souter says, and we think that he's talking about what could have happened.
Let's just stop. If there is no room for a recount, this election is over for Vice President Al Gore. All of his political aides and his closest legal advisors were saying if they lose on the recount question, it's over. And that's effectively what you're saying.
I see nothing that in any way is incompatible with that, Tom.
And that was how it ended. The presidential election in the year 2000 was decided not in November, but in December of that year, more than a month after the election, and it was decided at the courthouse. On election night, which had been 35 days before you just saw Pete Williams on the courthouse steps there, 35 days earlier, every other state in the union had turned in a definitive election result. But in Florida, it had been chaos. The state of Florida said that George W. Bush had won, maybe. The state's top election official, at least, who was working for the George W. Bush campaign, said it sure looked to her like George W. Bush had won. Ultimately, after recounts, after the Republican so-called Brooks Brothers riot to interfere with recounts, after the lawsuit that went all the way to the Supreme Court, ultimately what got recorded as the final result in Florida was George W. Bush winning the state by 537 votes. That's it. A nonpartisan independent count of all the votes cast statewide in Florida in that election later found that Al Gore actually got more votes. The independent nonpartisan count of all the ballots cast statewide gave George W. Bush somewhere between 60 and 171 fewer votes than Al Gore. But instead of that count becoming the results of America's Florida election that year, and therefore America's presidential election that year, that result instead just became a footnote to the presidency of George W. Bush. We don't talk about it much anymore, so I'm not sure how clear it is whether or not America is at peace with that election result in 2000. Events sort of overtook us very quickly thereafter. But even if you personally are not at peace with it, even if you are one of the people who thinks that George W. Bush stole Florida in 2000 and therefore stole the presidency, it is clear in hindsight, and it was clear at the time, that Florida could not have even been stolen, if you believe it was stolen. Florida could not have even been stolen had the voting result in Florida not been so close. Now, I don't say that to relitigate the last 12 years of American partisan politics, but rather just to underscore how close it was. That one really important number, the number of votes between these two guys in the official tally in Florida, 537 votes. When Florida Republicans took over the whole state government and state legislature in 2010, they changed Florida law to make it much more difficult to vote in Florida and much more difficult to register to vote there. Last week, the group Rock the Vote launched its Register Young People to Vote effort all over the country. Rock the Vote is a very mainstream, very nonpartisan organization. A number of the Republican presidential candidates went to a Rock the Vote event on the day of the Iowa caucuses this year to try to get young people to turn out to vote in the Republican caucuses in Iowa. But this year, the Rock the Vote voter registration efforts are going to be kicking off everywhere in the country, except for the state of Florida. And that's because of Florida's new voting law. The law makes it a criminal offense with huge penalties to do standard, regular old voter registration drives that have always been done in that state and everywhere else. It makes it so legally difficult to do them without running afoul of the law that the people who do voter registration drives feel like they cannot do it without putting themselves in criminal jeopardy. Since that new law went into effect, the League of Women Voters has stopped registering voters in Florida altogether, even though they have done it there for decades. One local chapter of the NAACP was just threatened with prosecution by the state of Florida for the crime of collecting voter registration forms on the Sunday of Martin Luther King Day weekend. They got people to sign up to register to vote on the Sunday of that 3-day weekend. Then they turned in those forms to the state. The first day state offices were open after the holiday, so on Tuesday. And that apparently was an illegal delay and earned them the threat of prosecution for having done that horrible thing. We've covered the story before of high school teachers in Florida being threatened by the state for the crime of registering high school seniors to vote. That is how fraught with peril the basic task of registering people to vote is in Florida now. Today, the New York Times released an analysis of the effect in Florida of the Republicans' new voter suppression law there. And it's kind of amazing. Look at this. In the month since the new law took effect in July, more than 81,000 fewer Floridians, 81,471 fewer Floridians have registered to vote than during the same period before the 2008 presidential election. More than 81,000 fewer people have registered to vote this year than in the last presidential election in Florida, thanks to Florida Republicans' new law that makes it harder to register to vote. That's what local elections officials told the Times they thought was responsible for the huge drop-off in new voters. They think it's the new law and the fact that there's no voter registration drives anymore. They've essentially been made illegal in Florida. In the last election, here's how new voters, first-time voters, broke down between Barack Obama and John McCain in Florida. Barack Obama won that group by 19 points. And now this year in Florida, thanks in part to the Republican voter suppression law, there will be 81,000 fewer of these voters. And that's just by now, by the end of March. Might those kind of numbers make a difference as to who is elected president this time around?
George Walker Bush,
in 2000, it was 537 votes. 537 votes, and then, of course, thanks to how close it was, also the even smaller number of votes that really counted in that election. And that, of course, was 5 votes. The 5-4 Bush v. Gore Supreme Court decision, which turned that close election partisan mess in Florida into the presidency of George W. Bush. And that was a stunning decision, right? I mean, all of the liberals on the court voted for the Gore side. All of the conservatives on the court voted for the Bush side. And there were more conservatives on the court than there were liberals. So George W. Bush became president. The court was so self-conscious about the spuriousness of its own legal reasoning in Bush v. Gore that the ruling said it could not be cited in future cases, that it was not precedent. In other words, we're not actually making law here. We just want George W. Bush to be president, okay? The Bush v. Gore 5-4 decision probably did mortal damage to the idea that capital C conservative justices on the court would act in small c conservative ways. They were perfectly happy to take what was pretty radical legal action, to depart wildly from legal precedent, as long as it achieved a political aim that they wanted. And if that idea of small c conservatism from capital C conservative justices wasn't entirely dead after Bush v. Gore, it got dug up and killed again in one of the court's next most high-profile cases, in Citizens United, where another 5-4 conservative majority on the court went so far out on a limb in terms of legal precedent that I think they actually might have had to jump onto another tree in order to stay aloft, in order to justify a radical legal remaking of corporations into people and of anti-bribery and clean elections laws into mincemeat. That was the last time the court bowed to public interest in what they were doing by releasing audio of the oral arguments in the case on the same day those arguments were actually made in court. Since Citizens United, the Supreme Court hasn't released audio that quickly again, until this week, until the health reform arguments that have now been taken up by the court. Here's some of what the Supreme Court argued over today during day 2 of those arguments.
All that sounds like you're debating the merits of the bill. You asked, really, for limiting principles so we don't get into a matter that I think has nothing to do with this case, broccoli, okay?
Broccoli. That was Justice Stephen Breyer trying to put a stop to all of the broccoli talk today in the oral arguments at the Supreme Court. Dolly Lithwick said on our air last night that she would be playing a broccoli drinking game at the Supreme Court today, where every time somebody said broccoli in these arguments, you'd have to drink. So we will have to see what sort of shape Dahlia is in after broccoli was brought up 8 times in the oral arguments, just as she warned us it would. But here's the overall political context for this big high-profile case, right? Heading into this big, high-profile, very partisan-inflected court case on this big achievement of Barack Obama's first term in office, Bloomberg News polled Americans last week on how Americans thought the justices would go about deciding this case. 8% of Americans said they weren't sure how justices would decide this. 17% of Americans said the justices would decide this case solely on its legal merits. And 75% said they thought the justices' own politics would influence how they ruled on this case. 75%. In other words, after Bush v. Gore, after Citizens United, we don't expect much as a country anymore from this Supreme Court. We do not expect that they're just out there neutral, calling balls and strikes fairly, making nonpartisan, objective legal judgments. If you go by what people tell pollsters, we think they're partisans. At least we think the majority of the court is a partisan body that will do anything to help politicians who are on their side and to hurt politicians who are on the other side. When busloads of anti-health reform protesters arrived today from the Koch brothers-funded Americans for Prosperity group, when they turned up in Washington, D.C. at the court today, it was hard not to connect that to Justice Clarence Thomas hearing that anti-health reform case today, even though he previously appeared as a featured speaker for the group that bankrolls this health reform is unconstitutional buses, this protest group. Clarence Thomas appeared at one of the Koch brothers' secret fundraising conclaves as a special guest back in 2008. On the day that the Supreme Court decided to take this case, Justice Thomas and Justice Scalia were both honored at an event held by the law firm that is arguing the anti-health reform case before the court today. Justice Thomas had to change his financial disclosure forms to reflect the fact that his wife has been a paid health reform is unconstitutional activist for a wacky Tea Party group that she founded, which, among other things, had very amazing headwear. And so today, as the conservative justices on the court, all in oral arguments, tipped their hand, at least seemed to tip their hand in questioning, to make it seem like they really do want to overturn health reform, this signature achievement of Barack Obama's first term as president. I think the short-sighted question, I think the question that is maybe so short-sighted that it is the wrong question to ask, is how might a ruling against the president's health reform law affect the Obama presidency and this president's chances at re-election? I think that is a short-sighted question and maybe not the right question to ask. Frankly, no matter whether they uphold this law or not, it's not like conservatives are going to decide they like health reform. Conservatives are still going to say they hate it. I'm not sure it's going to affect that much at all. The bigger question here, bigger in terms of its importance for not just what's going on in partisan politics right now, but for our system of government and our faith in it. It's not about how a ruling from the Supreme Court on this law is going to affect perceptions of this one precedent. The bigger and more important question, the more far-sighted question, is how this ruling could affect perceptions of this Supreme Court as an institution. And do they even care?